Thank you, Peter, for that wonderful introduction. And we've got quite an act to follow after these three speakers here today, so hopefully Brett and I won't disappoint you. We are what's known as the comic relief in our office. I say we generously, it's really Brett. So hopefully you'll find this a little useful and a little entertaining all at one time. Just a moment.
Ooh.
Don't worry, Ginger, I see what I did. So, Brett and I are here to talk to you today about new laws. And for those of you who have come to this for the last 4 years, you know we always do a segment where we talk about what new laws the state legislature passed, and we also talk about some cases that came out since the last time we all got together. This year we've broken that out into two segments, obviously the legislature side and then the case law side. But the state lawmakers this year were really focused and busy on gun laws and marriage issues and health and environment issues and some government oversight regulation for professionals that we'll talk about. But for the most part, from a real estate standpoint, the legislature's session was pretty boring. So while we have about 50 pages in your materials of updated, amended, or new laws that we wanted you to be aware of, and we're going to fly through several of them today, we're not going to go through all 50, there's really not a lot of land-breaking new statutes that you need to be aware of. The case law is a little more entertaining, and when we get to that section, I think that's really where the heart of this will be. So, So what did our state legislature do today, this last year? There were 613 bills introduced. Of those, 441 were enacted. There were absolutely no bills vetoed. Not even a line item in a bill was vetoed this session. Tells us a lot about the makeup of our current House and Senate and our governor. In comparison, in prior years, there's usually a handful of bills that are vetoed and set back. The biggest thing that passed in the last year would be the retail marijuana. And I know lots of you have heard about that since that came in last fall. Regulations and new statutes were adopted this session. Emergency rules went into effect July 1. We're not going to spend a lot of time on retail marijuana, but it is a big change in the law that everybody should be aware of, and it does have a lot of impact on businesses and commercial real estate because of the structure of the retail system that this law sets up. Before we jump into retail marijuana, I just want to give you a picture of exactly what areas the state legislature was working in. And as you can see, the property section of that, the profession sections of that, the water and ag is a small portion of what the state legislature really passed bills on in the last year. I put this up. I received this from my mother yesterday. Most of you who come to these presentations know I'm a dog person. Mr. Payton is also a dog person. So our goal today is to satisfy or at least pique your curiosity, but we're obviously not going to educate you in detail on every single law that came out. So what did they do to us for the marijuana laws? Amendment 64 provides that it is now legal in the state of Colorado to use marijuana. How many of you are very excited about that? I knew nobody was going to admit to that in open public. Under Amendment 64, you must be 21 to use. It's legal for you to possess 1 ounce. You may use it in private, but may not use it in public. Since we're in a public place here, I'm afraid that means no brownies for this presentation. You can own up to 6 plants for your own personal use. You may not sell it unless you are licensed. And that's a key one. I mean, you can't just go out in public now, despite all the concert goers I ran into this summer. You can't go out in public and use it. That's still illegal under Colorado law. You can give it to your friends. You cannot sell it to them. That raises the question of pot clubs. I don't know how many of you remember, as soon as retail marijuana was passed and Amendment 64 came into being, several pot clubs opened. One in Breckenridge, there's Club 64 in Denver, for those of you in the north side of Denver. They're essentially commercial establishments who have decided that their sole purpose in existence is going to be a place where people can meet and exchange freely marijuana, not sell it because selling it would make it illegal, but a place to use it for those whose landlords outlaw it or whose workplaces outlaw it. It's yet to be seen whether those are going to succeed. Right now they're trying to attack them based on smoking bans and air quality laws, but so far Club 64 is still open, so we'll have to see how that goes.
You're bogarting all the marijuana, so. One of the biggest issues there is you got to remember, if you have clients who are wanting to set up a grow operation or a retail shop, you got to watch your local ordinances. The local municipalities are allowed to prohibit these shops. There's a case in your materials of some folks who tried to set up a shop in a retail storefront, and it was against zoning laws, so they shut them down. That's okay under 64. Also keep in mind, if you got somebody looking into it, you're not going to be able to get a traditional loan. Banks are not going to loan on controlled substances because they're federally insured. So you need a lot of cash, or you need angel investors to come in and give you that seed money to get that going. The big umbrella issue, though, is still, of course, that it is still illegal federally. Right now, the way it looks like is if you get too big, you're making too much money selling pot, the feds are going to take notice, come in, shut you down. That's what's going on in California right now. So if you got a client who's wanting to do it and you want to do the transaction, just keep them small, okay? Fly under the radar.
You were talking about employers?
Oh, sure, yeah, good point. If you are an employer or you're an employee who uses, employers are allowed to prohibit you from using on the job, and also throw in, don't smoke and drive, right? There's issues with that because THC stays in your system longer, and state hasn't figured out how you measure impairment. When somebody's smoking, how do you measure up the amount of THC? Because you can still have THC in your system but not be high. So yeah, there you go.
So the most recent laws that were just passed, so the amendment passes in the fall, new laws come into being in this legislative session. Most of those were effective in May. As Mr. Payton said, it's don't smoke and drive. I think we all knew that. Contracts related to retail marijuana, the sale, the manufacture, and the production of it are legal. Obviously, that has to be the case or you can't set up a retail scheme. Visitors to Colorado can use it when they're here. They can't take it home with them. Interestingly, they also have a limit on how much they can buy that's less than what you can buy if you're a legal resident. Can't smoke in bars, and obviously there's a big tax coming. This was passed with the expectation that it would generate a lot of tax revenue. That tax still has to be approved by the voters this fall. It's anticipated, or at least as proposed, it would include a 15% excise tax and a 10% sales tax in addition to what the local governments will choose to put on it. And I've seen most of the local government proposals on the cities and counties that will authorize it, excuse me, are looking at a 10 to 12% tax in addition to these amounts. I apologize for that. The only other piece we wanted to talk about was the Colorado Department of Revenue's apparently I talked too much today. The Colorado Department of Revenue adopted emergency rules because they were required by statute to put these rules in place about how the licensing would work by July 1. Otherwise, it fell to the individual local governments. Department of Revenue, of course, was not going to let that happen, so without public comment, on July 1, they threw out a 62-page document that is their rules and regulations on how you get licensed to be a retail marijuana seller, grower, manufacturer, or producer. We expected big fees in that licensing structure, and I think those are there, although they're less than I thought they would be. Those fees range $500 if you're already licensed to do medical marijuana, $5,000 if you're not, just to apply as an individual to be able to do this. The business licenses run from about $2,500 all the way up to $14,000, and those will be annual fees to maintain your license to run these businesses. So it's going to be a significant money generator. Again, those licenses are not available till January of 2014. So let's move on to the new bills that we just wanted to highlight for you. These start in your materials under our new law section. Obviously, the marijuana laws are there, but we didn't want to talk about them separately. House Bill 1250 involves pest and weed control. Essentially, it increases the cap that a landowner can be charged by a county for the county having to come in and do pest and weed control up to $10,000, but it does prohibit the county from making you as the landowner do something different on your land or more than the county itself is doing on its own property. We also wanted to just mention Senate Bill 11. This is the bill that authorized civil unions in Colorado. There's nothing specific in the Civil Union Act that deals with real property, but there's a long laundry list of rights that they give to parties who obtain a valid license and with that license become civil united, I suppose. I'm not quite sure what you call that. We wanted to make sure you guys were aware of that because it will affect beneficiary agreements, it will affect inheritances. It does provide a witness protection. You cannot compel somebody who's joined in a civil union from testifying against their partner, just like a spouse. And there's lots of implications of this law that you just need to be aware that did in fact happen.
SB 13182, this is in addition to the Deceptive Trade Practices Act. This is with regards to the sale of timeshares. So if you're doing any transactions where there's a timeshare going back and forth, now there are certain things that must be in that transaction. You have to identify the timeshare entity, name, phone number, address. You have to give a legal description of the timeshare, which I know sometimes can be hard because it's just, 6 days a year in certain months and whatnot, but it's got to have a legal description. There has to be information about when are we going to close the transaction. Then the buyer has to have an opportunity to get out of the transaction as well. And if they do want to get out of the transaction, you got to refund any money back to them. Any failure to do any of the things now in the Deceptive Trade Practices Act makes the seller liable under the DCPA, which is now can result in treble damages. Next law is SB 1284, Uniform Commercial Code. Real simple. The idea here is just they amended the UCC to basically say, look, if you're filling out a UCC statement and just using the name of the individual, of the borrower, as it shows up on their license is sufficient. That's enough to identify the borrower and confirm the security interest.
Which brings us to House Bill 1138, which authorized public benefit corporations. I know we've talked about that at a couple of these updates that we knew this was coming. This year it officially passed. A public benefit corporation is a corporation that is set up and specifically intended to produce a public benefit and to operate in a responsible and sustainable manner. Those are words that I, as a business lawyer or a business litigation lawyer, love, because how often can we argue about whether you're being responsible and sustainable in your business practices? To set this up, you just have to include a specific statement that you want to be a public benefit corporation in your articles of incorporation, and you have to use the phrase public benefit corporation or the abbreviation PBC in your name. You can start doing this as of April 1st of 2014, and public benefit has a long definition in here if anybody's interested in doing this. It doesn't technically expand the requirements on the boards of directors for companies who want to be a public benefit corporation. They're trying to limit the ability of shareholders to sue because you're not doing the public benefit piece. Essentially what this sets up is you're required to report annually to your shareholders about your specific intended public benefit and how you're doing it. And if you don't do that report, shareholders can sue you for not doing that. It remains to be seen whether this is going to authorize shareholders to sue if they don't think you're accomplishing enough of a public benefit. So closely held entities in municipal court, we just wanted to briefly mention that Closely held entities can represent themselves in court cases. Previously, in cases in which the amount in dispute was up to $10,000, they've now raised that to $15,000. And for those of you who are inclined to get hefty fines in municipal court, the municipal court fine rate went up from $1,000 to $2,650.
SB 131043. So Jennifer mentioned, you guys all know that handguns were a really big issue this year in the state, and no matter where you stand on that politically, that's okay. This bill is absolutely amazing, though, in what it does. I'm going to read to you just the language. A deadly weapon shall be defined as a knife, a bludgeon, or any other weapon, device, instrument, material, or substance, whether animate or inanimate, that in the manner it is used or intended to be used is capable of producing death or serious bodily injury. I think that turns everything in this room into a deadly weapon, right? If you pick up your water glass and you intend to smack somebody over the head with it and kill them, it's now a deadly weapon, right? A magazine in the hands of Jason Bourne, deadly weapon. SB 13258, this bill with regards to land development is, I believe, to be a response to the Sterling Ranch case that we talked about last year. Sterling Ranch was a case in a developer. We had a huge multi-phase project, and the planning department required that he prove he had sufficient water for the entirety of the project before they'd even issue him the first building permit. The idea here now is that breaks that down so that the developer can prove he has sufficient water for each phase of that project. SB 13212, new energy financing. Last year, the state came up with a scheme, a way of encouraging different energy uses. They kicked it open to residential at that time. This law kicks that open to commercial uses now and adds in fuel cells as a defined new energy use.
So I was asked at one of the breaks or just before this morning whether I would offend anybody in this room. Apparently I'm about to offend any cat lovers in the room. My mother also sent me this yesterday. We include this in our presentation because we have discovered, thanks to Senate Bill 201, that now the state pets of Colorado are adopted dogs and cats. And as a dog lover, I'm quite happy about that. Not so sure about the cat part, but there's also a Dog Protection Act in Senate Bill 226. This was adopted in response to all of the police shootings of dogs that have taken place and have been in the news. Nothing really interesting for landowners, but if you're a dog owner, you'll be happy to see that.
SB 1167, Secretary of State information gathering. If you own your own business right now, they're going to start gathering information on the gender of the owners, race and whatnot, and then that's going to be made public. I think the idea is just to promote some minority businesses there. HB 13208, creative districts. Mike Payton told me yesterday I had to find a way to sneak in the whole North Colorado thing, and I think this is probably the best place to do it. What's a creative district? It's very Boulder, right? Okay, it's a district that the idea is we're going to have lots of art, public art, and this bill is just creating kind of the infrastructure financing for these new creative districts.
House Bill 1235 we included just for those of you who do sell property to the state. This new act will require that when that purchase price in the contract for the state to buy the property or to buy an option in the property is over $100,000, they must obtain an appraisal first, and there's certain approval requirements from the state comptroller that must be obtained before that contract can close. Are you talking about drug labs or was I?
I'll do contaminated property if you want.
There you go.
13219, contaminated property. The idea here is the state is wanting to give some guidance as to how do we know when contaminated property from an illegal drug manufacturing operation is cleaned up? How do we know we've used the right contractors? So they're coming up with some standards and some systems to make sure that contractors are doing their job when they're cleaning up the meth, and that they can test and make sure that the meth is truly gone.
So, I'm sorry, I apologize, we went too fast there. Senate Bill 111, we referenced because it requires the mandatory reporting to law enforcement if you suspect elder abuse. And it adds, the act specifically this year increased the amount of people they consider mandatory reporters, those who are committing a criminal act, who can be punished by, I think it's a misdemeanor offense, but it does include criminal punishment if you fail to report when you should. And elder abuse includes financial exploitation of an at-risk adult. They did change the age of an at-risk adult from 60 to 70, but the mandatory reporters now include bank personnel and court-appointed guardians and conservators. And so several of us in that room that certainly affects. So you want to be aware of this law. Interestingly, it does not yet include CPAs or attorneys.
SB 13119, as insurance companies are moving into the modern age, whether you believe that or not, they're going to want to start pushing your evidence of auto insurance to your smartphones so they can cut down on the amount of paper. This bill is designed to, well, this is the wrong bill. Apologies. This is the tax certificate. So I'm going to jump ahead real quick. I'll finish that one. When your insurance will get pushed to your smartphone, you can show that to the officer. That's an acceptable proof of insurance. The officer's not allowed to go through it and find all your nudie pictures and send them to his brother, if you follow the news. And then if he accidentally accelerates your phone at the ground when he gets pissed off at you, he's immune from any liability on that. This is, I do apologize, this is the tax certificate on the owner's policy. This is just basically for you title closers on a residential piece of property. You're going to be required to issue tax certificates on residential property now in order to close.
Not sure what exactly is on Brett Payton's phone, but I know I'm not going to look now. Senate Bill 125 involves prepaid funeral plans. Essentially now those who sell prepaid funeral plans, what they call pre-need plans, now have to be licensed through the state. The state can now step in and administer those plans if those funeral companies go out of business before they are needed. And interestingly, it contains a provision that you can sell the lot. You don't have to be licensed if you're selling lots in an undeveloped cemetery. Not quite sure why anybody would buy a lot in an undeveloped cemetery or how that would exactly work. I'll leave that to your imagination, but you don't have to be licensed if you are doing an undeveloped cemetery.
HB 13-1046, again, this is for employers, or if you're looking for a job, employers cannot require applicants or employees to give them access to their Facebook pages, their Twitter feeds, things of that nature. You can't require that they change their password so that the employer can get on and go through their personal posts and feeds and whatnot. The next one that's going to pop up is the naked pictures on your phone bill. We'll just call it that. How's that?
Senate Bill 188 deals with hunting on private property. It essentially takes all of the different landowner preference programs that existed throughout the state and creates one single program. It also increases the maximum number of licenses you can have for hunting on your property to 19 licenses per 600 acres. So hunters, be glad, lots of you can go at one time now.
SB 13202, there was only a very little oil and gas stuff this year. This is one of them. The COGCC they're gonna try to come up with a way of finding the riskiest parts of exploration and production and start doing inspections at those times. The idea here probably is because of the proliferation of applications for drilling, and they probably just can't get out to inspect them all. They're going to try to figure out when is the greatest risk of a spill going to happen. To help with that, HB 13-1278 is going to require that in the event of a spill, a producer must report to a COGCC and to local emergency response, fire, police, and whatnot within 24 hours.
So for those of you following along, we're roughly around page 30 of your materials on the new legislature laws. As all of you know from last year, mortgage loan originators have to be licensed now. Senate Bill 118 now exempts a broker from that licensing requirement if they are assisting a customer with seller financed transactions and do no more than 3 of those in a year. Senate Bill 155 reenacted all the provisions for licensing appraisers. It slightly changed what we call those appraisers now. There is no longer something called a registered appraiser. Instead, now we have ad valorem appraisers. Apparently, they wanted to sound more important than just a registered appraiser. So there are 4 categories of appraisers: certified general, certified residential, ad valorem, which are essentially your county assessors, and a licensed appraiser, which I think is still the trainee version going up. Fingerprints are now required for all applicants and all renewing applicants for appraiser licenses. The act, interestingly to me, also removed the requirement for new applicants to have to show good moral character in order to obtain an appraisal's license. Apparently now they just have to be honest, but don't have to have good moral character. And all of this is effective July 1. I also wanted to note that effective July 1, appraisers are also required now to carry E&O insurance, errors and omissions insurance.
SB 13161, this is with regards to architects and professional engineers and land surveyors. Biggest items here are that architects now must report any malpractice claims to the board. This also removes mental incompetency from grounds for which discipline can occur. In revising that to simply reference drug and alcohol use. So apparently, along the same lines, you can be mentally incompetent as long as you're not using while you're drawing out your architecture plans.
So you might be wondering why we have a picture of a woman playing bingo. This was my other new interesting of note statute they passed. I did not know this was an issue. Apparently there used to be a limit on the number of bingo and raffle games you could play in one single session. That was 35. Now it's unlimited. We can play as much bingo and raffle games as we want in a single setting. I know you were all really worried about that. So, common interest community HOA laws. This was a good focus of the legislature this year. They're trying to get a rein on these HOA boards who are running amok. These laws start on page 38 of your new law materials. Essentially, the homeowners associations now cannot prohibit the installation of an electric vehicle charging station. They also cannot prohibit xeriscaping. And the Senate Bill 183 specifically invalidates any provision in a declaration of covenants that prohibits or attempts to restrict an owner from xeriscaping their property. There are definitions of what it means to xeriscape. And it does not preclude an HOA board from implementing design standards for what that xeriscaping can look like, but they cannot outright prohibit it anymore. House Bill 1134 deals with the HOA Information and Resource Center. They have added the information that Resource Center can collect. They've implemented a study on HOA boards that this resource information officer is going to be implementing, but they still did not give this resource center authority or oversight power to enforce any laws. I still think that's coming, but it hasn't happened yet. House Bill 1276 addresses debt collection practices of HOAs, and I apologize, in that previous bill on the HOA enforcement or information center, they also have changed some of the registration requirements for HOAs, and they've made it specifically now that if you're an HOA and you fail to register, you cannot enforce your lien or collect assessments. So you have to make sure you're registered or you can no longer collect or enforce your liens. House Bill 1276, dealing with debt collection practices of HOAs, provides that by January 1 of 2014, every HOA must adopt collection policies that they must follow. Those collection policies must allow the homeowner to get a notice that they're in default or owe their assessments, and it must offer that homeowner a 6-month payment plan before any collection action can be taken. That means before the HOA can refer it to a collection agency, before they can sue, they have to give the homeowner a chance to get on a 6-month payment plan first. It also limited the ability of the HOA to foreclose on its liens. They cannot foreclose unless there is at least a 6-month value of assessments owed. So there has to be a certain threshold, monetary threshold met before they can foreclose. House Bill 1277 requires professional property managers also to be licensed, and all of these HOA bills, which amended Kiowa that came into effect in July of 1992, typically applies to HOAs formed on or after that date. All of these provisions now apply to every HOA, whether it was formed before or after Kiowa.
HB 1307. This is with regards to legal descriptions in title documents. If you remember last year, we covered In re Rivera, also known as Sender versus Seigan, in which there had, on the deed of trust, they had forgotten to attach the legal description, and so all they had was the street address of the property. And in that case, the Supreme Court said, well, that's insufficient. You need the legal description. This statute is in a direct result and says, no, that street address is significant in order, or sufficient, excuse me, to make that title document valid and enforceable. We'll move into some, HB 131029, authoritative verbs. Brent mentioned this earlier. This is clarifying apparently something that was confusing to many people. The word must is now defined as having its standard understood definition, meaning you have to do something, and shall means that a person has a duty. Wasn't really aware there was a problem there, but leave it to the legislature. HB 13221, we're going to move into some tax issues real quick. This is with regards to income tax and conservation easements. This has to do with documenting your conservation easement for the purposes of income tax deductions. The really nice thing here is this also allows the landowner to get a preliminary opinion as to what their deductions will be on the conservation easement. The major thing is it is preliminary. It's not a binding opinion, but it gives them an idea so they can do their tax planning and decide whether or not they want to move forward with the transaction. HB 131145 has to do with the senior tax exemption. The old law said that if you didn't get your tax exemption in, if you are a qualified senior, if you didn't get it in by September 15th, you had to have a good reason that you didn't get it in. They got rid of that, so now you can just have whatever reason you want for being late. HB 131183, again, another conservation easement bill. This one just steps up the amount of deduction to $45 million each of the 3 years from 2014 on, and then increases the wait list cap to $15 million if you can't take it all in those 3 years.
Which brings us to the last of our new laws we want to talk about, which is water. Senate Bill 41 just corrected a Supreme Court decision from 2 years ago in which the Supreme Court held that storing water was not a beneficial use. Seems funny in a drought-ridden state like ours. Legislature has fixed that. It is now. Senate Bill 78 deals with how you correct a point of diversion for a decreed water right if for some reason you got your point of diversion decreed and then built it elsewhere. This is the statute you would turn to fix that. And House Bill 1044 authorizes the use of gray water, of course being household used water, I'm going to call it. And there are specific standards set forth in how that happens. Before we move on to case law, we just want to give you a brief preview of some of the things to look for next year. These are things that we expect to come up and things that almost passed this time but didn't quite get through. The most important of these would be on they are looking at doing a new disclosure form in residential transactions in which you would be required to provide a disclosure form that the mineral estate may be separately surface runoff from Teddy Gomez's place. Teddy Gomez, being the entrepreneur that he was, noticed that although Ralph had decreed water rights, he wasn't using them. Teddy thought, aha, I'll go do that. So he starts using all the water that's coming through the ditches that should be going to Archuleta, uses it on his own property, does so from 1968 to 1991. Not sure what Ralph thought was going on with his water. Apparently water wasn't short for him. Teddy, in the meantime, has been using it all this time until in 1991, Ralph walks over and says, hey, Teddy, what are you doing at my head gate? Why are you taking my water? Teddy says, that's not your water. This is my ditch. I've been using this for 30 years. It's mine. An altercation ensues. I imagine there are pitchforks and shovels involved. There are criminal charges involved. And the 20-year litigation begins over whether or not you can adversely possess someone's water rights. We learned from the first time this case went to the Supreme Court a couple years ago that yes, you can adversely possess someone else's water rights. The case that just came out this year sets forth in hyper-technical detail, as only Justice Hobbs can do, how you prove you've adversely possessed someone's water rights. It goes into details about flow rates, the reason you're using the water. It's very detailed. If you're trying to adversely possess someone's water rights, this is the case you should look at. From our standpoint, I think the important lesson here again is don't let somebody else use your water for 30 years without saying something, because you're not getting it back if you do.
Doing the cases is so much fun because truth is truly stranger than fiction. Deutsche Bank versus Samora. You'll find this around about page 3 in your materials. Samora, in the late 90s, bought a house in Denver. 2003, she decides she wants to refinance. So she goes to see two mortgage brokers, Gonzalez and Medina. And they say, we'll be happy to get you a new loan. Come on in, fill out all the paperwork. She does all that. She signs all the stuff they want her to. They then head into the back and get a quitclaim deed, fill it out themselves, and transfer the property. They forge her signature and transfer the property into Gonzalez. Samora goes home. She thinks she's got a new loan. She's happy to go. She's refinanced. She's good. Gonzalez goes out and gets a $37,000 mortgage on the property, pockets the cash, and goes about his nefarious dealings. A year later, Samora strolls into her bank. She wants to refinance again and get a better rate. She sits down with her banker, and the banker starts reviewing the title work and says, well, you don't own the property. Gonzalez does. She had no clue. So she goes storming into Gonzalez and Medina's office and says, what the heck are you guys doing? How could you take my property from me? That's ridiculous. They say, oh my goodness, what a complete mistake. We were unaware that that happened. We're so sorry. They quitclaim the property back to her. She thinks, okay, everything's all right, but realizes later she still wanted to refinance. So who does she go see? Gonzalez and Medina. They say, okay, we can get you a loan, not a problem. Check it out. Medina's girlfriend works for Saxon Mortgage. We're going to help you out. We'll get you a great loan. She sits down with Medina's girlfriend. They fill out all the paperwork. Medina's girlfriend hands her a warranty deed, transferring the property into Medina's girlfriend's name. Samora does not read what she's signing, signs it, goes about her day thinking she's got a great new loan. Medina's girlfriend goes and gets another loan for $172,000 on the property. No one ever services the mortgage. Through a bunch of transactions, Deutsche Bank ends up basically being the holder on the deed of trust. Medina and Gonzalez go to jail because Deutsche Bank starts foreclosure. Fortunately, the Rule 120 action was stayed. The court would not sign off on the 120. They forced Deutsche to go through judicial foreclosure. That's the only good news for Samora. Unfortunately, because she actually signed that second warranty deed, the court says it's voidable, but not void, and that there was no fraud as between her and, we'll say Deutsche Bank, they were not the original lender, but as between her and Deutsche was ultimately allowed to foreclose on her property on the $172,000. I put up here, the real lesson is, you don't put a burglar in charge of all the goods and then hire him again after you get robbed on his shift. The reality here is you gotta inspect those documents. You gotta make sure what you're signing and who's controlling that transaction.
So on page 8 of your materials, we have the only broker case that was really reported of interest this year, Gibbons versus Ludlow. In Gibbons versus Ludlow, Ludlow was a seller of about 131 vacant acres of land in Boulder. He retained Gibbons White to broker his sale for him, entered into an exclusive listing agreement with them. And for the next 7 years, they had the property on the market, got very little interest, a couple of offers to purchase 10 acres here or 12 acres here of this 131 acre tract. Finally, in 2007, an LLC comes in and says, all right, we'll come in and buy 49.2 acres for $6.4 million. But we want, and this states in the offer they provide, and Brent mentioned why he does not like the offer, counter proposal system. This is probably a good example of why not. The LLC comes in, makes an offer, and says, we'll buy 49.2 acres, but we want a reimbursement agreement, and we want closing to be contingent on it, so that you have to put in infrastructure on this property, and our costs of it are guaranteed. So they'll split the cost of the infrastructure, but if you don't put it in, we will deduct our share of those costs from the purchase price. So there's a deduction provision that allows them to reduce the purchase price if certain infrastructure is not included. Seller rejects this proposal, makes a counter proposal, but in their counter proposal, they only deal with certain amount of acreages. They talk about a couple of provisions. They do not touch this deduction provision. Said, LLC says, okay, we'll do this deal. They go forward. They get a week before closing. Seller's property statement comes out, and lo and behold, no infrastructure's been put in. They have a $1.6 million reduction noted in the purchase price, and the seller says, hey, wait a minute. What is going on here? I was not aware there was any reduction possible in this purchase price. Seller says, I can't close on this. Broker and you, my attorney, didn't tell me this was in this offer that we accepted. Broker says, well, I'm sorry. Attorney says, well, I'm sorry, but you're obligated to close, and if you don't, you're going to be sued by this LLC. So they go forward with the transaction and close at $1.6 million less than the original agreed purchase price. Immediately after closing, what happens? Broker and attorney get sued. Attorney settles out somewhere along the way. Broker says, hey, wait a minute. I acted as a transactions broker in this deal. I wrote the contracts, but I owed you no obligation to tell you everything that was in this contract. And by the way, you had no other buyer out there willing to pay you $6.4 million for this property. You could not have sold it for that, so you can't sue me because you can't prove damages. And this goes all the way up to the Supreme Court, because the Supreme Court's looking now for, ironically, what is the first time about when a transaction broker is going to be held liable for damages in a situation like this, where they assume the broker's negligent in not providing or not telling the seller that this provision was in there, and clearly the seller's now lost what it thinks is $1.6 million. The Supreme Court says, unless the seller can prove that but for the broker's actions, they would have done a deal at the higher price or would have earned more money than they got from the sale by not doing the deal at all, that broker is not liable. It's a great case for brokers because it really limits your liability, because it's going to be really hard to prove in the absence of a bidding war situation that you have another buyer ready to walk in and pay you a higher price, because if you did, you're probably going to sell to that buyer in the first place. So if you're a broker and the lesson for us here is to make sure if you're a broker, don't put anything in the contract your seller doesn't know about. And if I were you, I would advise that you make sure your sellers are at least initialing or signing off on the page where it specifically says the purchase price could be reduced prior to closing. So DCP Midstream versus Anadarko is a unique case. It's one that I love as a litigator because although it screams oil and gas, it's really not an oil and gas case yet. It went up to the Supreme Court on discovery issues. Ironically, there were no reported oil and gas decisions this year in the appellate courts. I think we all know there's oil and gas litigation going. This case is one of them. But they haven't made it up to the appellate courts yet, either because they're just not at that process or because they're settling out, as we tend to see when there's lots of money in an industry. This particular case, DCP has sued Anadarko, claiming that when it bought out Kerr-McGee's transport company and Kerr-McGee Oil and Gas LLC, it took over the contracts, about 50 of them that DCP had with Kerr-McGee, that gave it the exclusive right in about a 684 square mile area in the Wattenberg field to transport oil and gas produced there, whether it was new or existing wells. Anadarko, of course, took over Kerr-McGee and then started using their own producing transport company instead of DCP. In this particular case, they get past the answer stage. DCP sends Anadarko a request, some 60 requests for production, asking for, as termed in the opinion, millions of pages of electronic and hard copy documents, including every title opinion that Anadarko had for the entire Wattenberg field. And you can imagine how many title opinions that must be. Anadarko, of course, refused, said, look, you're fishing, you've only made a complaint for 11 contracts, we shouldn't have to do this. The trial court judge over in Weld County said, well, in our county, the rule is if you ask for it, you get it, and I'm not at liberty to withhold or to restrict your discovery process. Supreme Court here says, well, that's not entirely true. I think they were looking for a case to come in and say some of this over-the-top discovery, this idea that you can file a complaint and then go fishing for new claims, is probably coming to an end. They wanted a case to really come out and say, nope, we're going to treat this practically, and we're going to limit discovery. And they're giving the trial courts wide latitude in shaping and limiting the discovery that can be done. Interestingly, Anadarko asked the Supreme Court to specifically find that title opinions are per se not disclosable because they are attorney-client privileged. And the Supreme Court would not go that far. The Supreme Court said, nope, you've got to look at every single title opinion to see, is it really communicating an attorney's opinion about the state of record, or is it just reciting the record of title that exists? Unfortunately for Anadarko, I think that means they now have to do a privilege log for every single title opinion issued in the Wattenberg field. So we'll see. I'm sure this case will be back, but for now, it's really great for those of us trying to avoid massive discovery requests.
State v. Lobato, we wanted to throw this in here today. Obviously, this doesn't deal with real estate per se, but the idea here, and the reason we wanted to just at least bring it up, was that Lobato is confirming that taxes related to education can be locally controlled, they can be locally driven, they can be, you can determine how they're used at the local level. Hopefully that helps improve some of our school districts. And the other thing is that as professionals, we'd all hope that we could get involved in things like that, pay attention to what's going on at the local level. Greeley Chamber of Commerce has got a big push on education in Greeley. So we just wanted to mention Lobato here briefly.
Shaw versus 17 West Mill Street LLC is a case we talked about 2 years ago when it came out in the Court of Appeals. It involves the unauthorized request for a release of a deed of trust from a public trustee. And if I were going to tie this into Mike Payne's presentation, he talked all about what happens through the life and death of a real estate loan. He didn't talk about what happens if a third-party cheating spouse appears. This is probably the cheating spouse case. In this particular case, two developers are sharing office space. They decide to do lots of deals together. Occasionally, those deals include loaning money to a third developer. As part of that process, the borrower's attorney would always prepare a release of a request to release the deed of trust that it would be sent to the public trustee. He would get a letter from the lender saying, please release, it's okay. He would then sign for the lender and send the request off to the public trustee. On the particular occasion that led to this lawsuit, lender went to Honduras on vacation, wasn't around to sign the letter. Attorney said, well, we've always done it this way in the past. We've got a deadline to close here on this particular deal. I'm sure it'll be okay if I do it now. I'm sure he authorized it. My client said he did. So he signs the request for the release of deed of trust anyway, sends it off, deed of trust gets released, property gets sold to a third party. General lender comes back from Honduras and says, why have I not been paid on this loan? Discovers he doesn't have a deed of trust anymore, and of course we end up in court. From a legal standpoint, what the Supreme Court has said here is that in order to invalidate a public trustee's release of a deed of trust, you have to show actual fraud. It's not enough to say, well, you made a false statement in your request or it wasn't authorized. There has to be actual forgery and actual intent to defraud somebody. And in this case, because that attorney, although he made lots of false statements in his request, such as that it was authorized and that he knew the loan had been paid off, he didn't do it intentionally believing he was committing fraud, and because of that, it was not enough to invalidate this particular deed of trust release.
Asmussen versus U.S. This is a case with regards to lot boundaries and railroad bases, railroad beds. The case primarily, this is a Supreme Court case. The question was, in the event that there are two adjoining properties, where's the property line? Is there a presumption that it goes to the middle of the railroad or that railroad bed? Supreme Court said, yes, it does. However, lesson learned here, before you go all the way to the Supreme Court, make sure you look through all of your title documents and make sure that you actually have a legal description that goes all the way to the middle of that railroad bed. The result out of this case was that they said, yeah, you go to the middle, but for Asmussen, he actually didn't own up to the middle. His legal description fell short of the railroad tracks. So it's a lot of time and a lot of money to go to the Supreme Court when you don't actually own that property. Weinstein versus Colburn. Clay Bartlett in our office did a good article on this case in our last newsletter. Shameless plug. Weinstein got a judgment against Colburn Foods, an LLC. The members of Colburn decided they didn't want to pay that judgment. It was kind of big. They weren't really happy with it. They didn't like the result. So what they decided to do was make a distribution out to the members and bleed the LLC dry. So there's nothing left for the judgment creditor to attach in the LLC. Weinstein, gets mad. Hey, you've got a fiduciary duty to your creditors. This is a legal transfer out to members. I'm suing the members. Supreme Court says, nope. The only person who can hold that lawsuit is the LLC entity against the members themselves for an illegal transaction and an illegal distribution, and there is no fiduciary duty to your creditors. Jennifer mentioned this. This is bound to be changed because that leaves that judgment creditor holding an empty bag. All right. There's two ways to look at this. One, if you're in an LLC and you got a judgment against you, apparently go ahead and bleed it dry. All right. Not really recommending that. If you're on the other side of that equation, if you're loaning, something like that, look for personal guarantees with the members, some way to hook the members in. Okay.
This case is one that's, of all the cases that came out from the Supreme Court in the last year since we were last all standing here, this is my favorite. And this is one that really has split the creditor attorney from the business attorney. I think what we're about to see in the legislature is a lot like my cartoon up here right now, where there's going to be a lot of bickering back and forth from the business bar who really wants to protect and make these limited liability companies truly limited, almost completely unlimited liability for business owners in order to encourage investment and new business opportunities. Creditors, of course, are looking at this saying, what do you mean? They have no obligation to pay their creditors and they can pay themselves first, knowing they owe a judgment or owe me money. That seems patently unfair. I do expect this to come out in front of the legislature where they're going to be asked to extend the corporations law that says you cannot do a distribution like this in violation of your obligations to creditors. I expect the business bar to oppose it. I think it'll be a really interesting thing to see how that turns out next year. But the lesson here, as Brett said, make sure you count your money and run if you own an LLC.
Hog's breath. This is an insurance case, but the facts are a ton of fun. This came up a couple years ago on the Court of Appeals side. This ended up at the Supreme Court. Basically, here's what happens. Hog's Breath Saloon, for years, dumps all of their cooking grease down a drain in their kitchen, all their animal fats and all that stuff. Over the years, it turns out to be a 5 foot to 8 foot long animal fat plug in the sewer, all right? So it starts backing up all the sewer systems in the adjacent businesses. The city sends a crew out, hey, let's go figure out what's going on, fix this thing. Guy goes, pulls the manhole cover off. What do they call it? It was hydrogen sulfide. Comes blowing out of the manhole cover into his face. He immediately passes out and falls into the manhole. Manhole cover follows him. You know, they're designed not to go down the hole, but it closes on top of him. His coworker sees this happen, goes running over, pulls the manhole cover off, gets hit in the face with hydrogen sulfide, passes out, and falls in the manhole on top of his buddy. So they sue Hog's Breath for damages. Hog's Breath sought coverage under their insurance policy. The carrier originally denied under a pollution exclusion. The Court of Appeals said, no, you know, there's damages here. The Supreme Court here says, no, look, your pollution exclusion is pretty clear. Hydrogen sulfide is a poisonous gas that Hog's Breath has emitted into the environment. There is no coverage because of that pollution exclusion in this situation. Yale versus AC Excavating is a situation of general contractors and subs. AC was a sub. Yale was a member in the general, which was an LLC. The excavation company had done a ton of work, somewhere close to $300,000 worth of work. The general was running out of cash, had paid him about $127,000 roughly, but it was really running lean. So Yale, as one of the members, makes a capital infusion into the LLC of $157,000 and then starts paying bills with it. He's not able to pay the AC Excavating bill, so AC Excavating decides to file a lawsuit under the Mechanics Lien Trust Statute, claiming that his capital infusion should be owed to them. Supreme Court says, no, that's not the way the trust fund statute works. The way it's supposed to work is that funds that should otherwise go to that sub are captured by the trust fund. The investment or the capital infusion by a member is not designated for that sub, so they are not required to make that payment to the sub under the trust fund statute.
LaRue versus Best Buy, we can do very quickly. I think everybody knew this, but if somebody's injured on your land, you're more likely to be sued now following this case. This case essentially is somebody went to Best Buy, bought a freezer, brought a truck over to try to load that freezer in. He and the Best Buy employee went out to the truck, took the tailgate off. I didn't know it was possible to remove an entire tailgate from a truck in a parking lot. Apparently it is. When they're carrying the tailgate away, the buyer of the freezer tripped on the curb, tailgate falls on top of him, he's injured, and of course that's Best Buy's fault. What this case is important for is for all of you landowners out there, what it says is you can be sued under the premises liability statute now, even if the reason for the injury had nothing to do with the land itself that you own. In other words, just because you are selling products on your land and during that activity somebody gets hurt, you now can be sued under the premises liability statute for that injury.
Fidelity National versus First American. This case arises from when security title used to exist. A local developer, well, real quick, First American had an underwriting contract with Security. Security is now Fidelity. Fidelity's a sponsor. Thank you. Go visit their booth. They ended up holding the bag on this because they acquired Security. Okay, so we'll try to refer to Security throughout this. The local developer wants to get a project going, big project. So he goes and he gets two loans, one from Brown Financial and one from Colorado East Bank. First American assigns the file to Security to do the underwriting, and they underwrite both loans, okay? Security tells both lenders you're in a first position. First American says, hey, guess what? That's not possible. We need you to get a release of the Brown financing. Now, before that had happened, Brown had sold the loan to Academy Bank. Security knew that the loan had been assigned to Academy. They had all the documentation. Security gets their instructions from First American, and they go to Brown and say, we need you to release this. Brown says, don't worry about it. I'm not owed anything under it. I'll give you a release. You don't have to pay me anything. Great. Security says, no problem. We can close both loans. Don't worry about it. Of course, I hope there's no developers in the room. He's a developer, so he doesn't service either of the loans. Both go into default. Academy and Colorado East begin foreclosure proceedings on the project. What it comes down to is First American jumps on securities. They reach a deal with Academy. They pay Academy off that allows Colorado East to move forward with their foreclosure. First American then sues Security for the $986,000 they had to pay to Academy. Supreme Court says, yep, you're liable for that, and the best part is they said Security should have known you can't possibly have two separate lenders with different money in a first position on the same piece of property.
Which brings us to our last case. This one, I'm afraid, is not in your materials. It is a U.S. Supreme Court case, which we don't usually talk about, but it's also very rare that a development case gets all the way to the U.S. Supreme Court. This one is interesting only insofar as I think it gives landowners who are submitting an application for a development or a development application to a local municipality or a local governing body who are being essentially extorted to try to get lots of conditions that seem unrelated to their project. This gives you a takings claim if that happens, even if, because of those conditions, the governing body denies your application. So in this particular case, a gentleman down in Florida was trying to develop 15 acres of land, a corner of which was wetlands, because Florida law says if you're going to develop property, any of which is a wetland, you must, of course, do environmental damage mitigation. He proposes to give 3/4 of his property to the district in exchange, as a conservation easement in exchange for developing 1/4. District says, nope, that's not enough. We want to protect the rabbits and turtles that live out there. We want you to either reduce the size of your project and give us 90% of it as a conservation easement, and we'll let you develop 10%. Or you can pay us a certain amount of money that's necessary for us to go make improvements to this area of wetlands we have 6 miles down the road, completely unrelated to your project. But they denied his application initially and then told him those were the only conditions under which they would approve it. Developer's unhappy, he sues, goes through all of the Florida courts, gets all the way to the Supreme Court saying, that's in effect a taking of my property because you're telling me you will never let me do anything with it unless I meet your unwarranted and unrelated conditions. The U.S. Supreme Court said, yes, we agree, that's a taking and it's not proper. I raise this because I think it gives us litigators anyway something new to claim when we've got landowners who are frustrated in the development application process with county governments that are imposing conditions that seem completely unrelated. May also give you a little negotiation power with the right government entities. What we learn next year are cases pending currently on review. Most of these involve what does or does not constitute a public facility for which you can sue the government. That's what we'll learn next year. The last one, of course, right now the Supreme Court is reviewing whether the defense of latches, which is essentially you waited too long to bring a claim, is available as a defense to a note collection action. So if you wait too long, but presumably not beyond the statute of limitations, I think they're going to look at whether that means your note is now not enforceable. I can guess which way that's going to come out. As those of you who know us, or at least know me, know I always end every presentation with a photograph of my dog. This is Timu, named after the hockey player. If you look really closely, you'll see my father's dog at the top of the stairs. His name is Mika, named after also a hockey player. You sense a theme in our family. We want to thank you very much for coming today. We're very grateful to have all of you here present. We're especially grateful to all of our sponsors, including our premier sponsors, Anton Collins Mitchell and National Inspection Service. We hope you learned something good today. We hope you had a little bit of fun today. We very much hope you come back next year. We'll keep doing this as long as you guys keep saying you're coming and you're interested. Please fill out your evaluation forms before you leave. They are very useful to us in making sure we talk about what you want to hear. Please make sure you leave your CLE affidavits completed with the ladies at the front. If you need a certificate of attendance, they also will have those ready for you. I think several of our speakers will be around up front. Again, I told you we might be playing a Pictionary game. We'll also be around to answer questions if you'd like. And otherwise, I just need to thank publicly for the second time. I know Mike Payton did this earlier, but this event does not happen without the support of our staff, who are tremendous. And in particular, Ginger, who makes sure all of our technology runs smoothly, Kim, who stayed back at the office to run our webinar, Mike, who helped put together materials, Pam and Felicia and Tana, who's been here running everything, and in particular, BB Thomas, who you all met out front. She took on this project new to our firm, having never seen it, and I have to say, she managed to get me to prepare a week in advance, which I've never done, and this went off smoothly, I think, in large part due to them and to BB's efforts. So please thank them as you see them on your way out, and we hope to see you again next year.